Hi, this is Curt and welcome to another edition of Fire Law Roundup.
LA County, this is actually, I think it's kind of typical in some sense, but here you have a drug test administered. The drug test comes back with what was alleged to be a false positive. And apparently, I think you commented, is a very well-known false positive for somebody who's taking with attention deficit disorder. It comes up, an amphetamine comes up as methamphetamine. So the individual, rightly so, is placed on leave or suspended, but asked for reconsideration. What they do, which of course is pursuant to their policy, every good drug test does a split sample. So they said, listen, we're not going to do a different type of test, but we'll run the sample again. The problem is that there's no problem with the sample, right? It's a problem with the result, that the result is going to render a false positive for methamphetamine for an amphetamine. So this person's now, looked at as a drug user, right? And is claiming, look, it's for ADA. It's like saying I ate a bagel with poppy seeds. I may have tested positive, but
I've had that
right?
one, yeah.
So in any event, the individual's terminated. And it's, there's a lot of violations. You've got ADA, right? You got the Recovery Act, maybe. I don't think that's been alleged, but I could see that kind of. But, the ADA is the big one. But now and it's interesting, people should understand, one of the things they allege is failed to reasonably accommodate my disability by giving me a drug test that doesn't come up false positive. I think that's a good claim. I've seen that other places. I don't think this attorney's making it up. There's a good history with that. But as an employer, look, run your drug test, fine, do the split sample. But if you can do basic research, and maybe they did, but you would find out, right, that no, this test has a history of false positives, come up with another way. And the employee was willing to share the drug and the reason they're on the drug, which they don't have to do. The burden shifts, right? Now the burden should go back to the employer to say, we've got to come up with a test that doesn't pop false with this type of drug. And I don't know whether this is a problem employee where they were happy to get rid of the person because,
Well, I didn't include this in the write-up, but apparently in the complaint, he referred to himself as having acquired the nickname of Sleepy Joe.
Okay.
So, and he said that it was related to his disability and inability to sleep, and he'd come to work tired, and there was several reasons for it. Maybe even his medication, but at any rate, he had somehow acquired the affectionate nickname of Sleepy Joe. His first name is Joe. So
yeah, okay. Well, he's probably not our president, but so this is a good example of a bad employer practice. And if the employer wanted to get rid of the employee, this is not the way to do it. ADA claims, is not something you want to face. And his allegations are pretty strong, assuming it's true, his allegations definitely, force, as a matter of law, are going to force the employer to explain why they wouldn't accommodate a test. I think this is going to come down to a lot of science argument, though, right? Because you've got to show that the test is a false positive and it has a history.
Just because somebody is on amphetamines doesn't mean they could not also be recreating with methamphetamine,
right?
So that's another possibility. I'm going to tell you, I know a number of chiefs from LA County, and they're squared away. Their front office is as squared away as any fire department is. So, there's probably more to this that we don't know. Always. But I think it's interesting. The flow, the facts, the flow of the case, and how it got to court. I think is interesting for folks to understand, and we'll see where it goes from there.
Yeah, there'll definitely be more on this. You got to imagine that the county is saying we could show the test is valid, or we could show something else. But in any event, it goes back to something we talk all the time: the burden shifting analysis, which we did a lot on the other week. Right? Is you made they clearly made what's called a prima facie case, right, of discrimination. I think they did. And now the burden is going to shift back to the employer to say, no, we had a reasonable basis for denying the request.